remembered for his contribution, values and inspiring life. I now request Mr. Goutam Chand, President KSBC Law Academy, to kindly deliver the welcome address, sir.
ಎಲ್ಲರಿಗೂ ಕರ್ನಾಟಕ ವಕೀಲ ಪರಿಷತ್ತು ಲಾ ಅಕಾಡೆಮಿಯ ಮಾಜಿ ಅಧ್ಯಕ್ಷರಾದಂಥ ಹಿರಿಯ ವಕೀಲರಾದಂಥ ಶ್ರೀ ಬಸವರಾಜರವರ ಕನಸಿನ ಕೂಸು. ಯಾರ್ಯಾರು ನಮ್ಮ ಹಿರಿಯ ವಕೀಲರು ನಮ್ಮ ಸಮುದಾಯಕ್ಕೆ, ಟು ದ ಲೀಗಲ್ ಫ್ರೆಟರ್ನಿಟಿ ಹೂ ಆಲ್ ಹ್ಯಾವ್ ಸರ್ವ್ಡ್, ಇನ್ ದೇರ್ ಮೆಮೊರಿ ವಿ ಹ್ಯಾವ್ ಡಿಸೈಡೆಡ್ ಟು ಕಂಡಕ್ಟ್ ಲೆಕ್ಚರ್ ಸೀರೀಸ್ ಆರ್ ಅಟ್ಲೀಸ್ಟ್ ಒನ್ ಲೆಕ್ಚರ್ ಇನ್ ದೇರ್ ಮೆಮೊರಿ. ಸನ್ಮಾನ್ಯ ಪುಟ್ಟೇಗೌಡರು ನಿಮ್ಮೆಲ್ಲರಿಗೆ ಮಾದರಿ ಟು ದ ಎಂಟೈರ್ ಲೀಗಲ್ ಫ್ರೆಟರ್ನಿಟಿ. ಸನ್ಮಾನ್ಯ ಪುಟ್ಟೇಗೌಡರ ಬಗ್ಗೆ ನಾನು ಹೆಚ್ಚಿಗೆ ಏನೂ ಪ್ರಸ್ತಾಪ ಮಾಡಲ್ಲ, ನಿಮಗೆಲ್ಲರಿಗೂ ಗೊತ್ತಿದೆ. ಇವತ್ತು ಅವರು BBMPಗೆ ಮತ್ತು ಇತರ ಸರ್ಕಾರಿ ಸಂಸ್ಥೆಗಳ ವಕೀಲರಾಗಿ ಯಾವುದೇ ಆಮಿಷಕ್ಕೆ ಒಳಗಾಗದೆ ಸರ್ಕಾರದ ಸಾವಿರಾರು ಕೋಟಿ ಆಸ್ತಿಯನ್ನು ಕಾಪಾಡಿಕೊಂಡು ಬಂದಂಥವರು. ಸಾರ್ವಜನಿಕ ಜೀವನದಲ್ಲಿ ಪ್ರಾಮಾಣಿಕತೆ, ನಿಷ್ಠುರತೆ, ಸಹೃದಯತೆ, ಎಷ್ಟೇ ನಿಷ್ಠುರರಾಗಿದ್ದರೂ ಮಿದುಭಾಷೆಯಾಗಿದ್ದರು, ಹೇಳೋದನ್ನು ಸ್ಪಷ್ಟವಾಗಿ ಹೇಳ್ತಾ ಇದ್ದರು, ಮಾನವೀಯ ನೆಲೆಯಲ್ಲಿ ಮಾತಾಡ್ತಾ ಇದ್ದರು. ಮಾತಾಡೋದಷ್ಟೇ ಅಲ್ಲ, ಅವರು ಅದೇ ಥರ ನಡ್ಕೊಂಡಿದ್ರು. And therefore, Karnataka State Bar Council Law Academy has organized this lecture in his memory. When we requested Senior Counsel ಹೃತ್ಪೂರ್ವಕ ಸ್ವಾಗತವನ್ನು ಕೋರುತ್ತೇನೆ. ನಮ್ಮ ಕರೆಗೆ ಹೋಗ್ಬಿಟ್ಟು ಹಿರಿಯ ವಕೀಲರಾದಂಥ ಶಂಕರನಾರಾಯಣರವರು, ನಂಜೇಗೌಡರು ಮತ್ತು ಎಲ್ಲ ವಕೀಲರು ಬಂದಿದ್ದಾರೆ. ಅವರಿಗೂ ಕೂಡ ಕರ್ನಾಟಕ ವಕೀಲ ಪರಿಷತ್ತಿನ ಪರವಾಗಿ ಹೃತ್ಪೂರ್ವಕ ಸ್ವಾಗತವನ್ನು ಕೋರ್ತೇನೆ. ಈ ಒಂದು ಲೆಕ್ಚರನ್ನು ಆನ್ಲೈನಲ್ಲಿ ನೋಡ್ತಾ ಇರುವಂಥ ಎಲ್ಲ ಮಹನೀಯರಿಗೂ, ಇಲ್ಲಿ ಭಾಗವಹಿಸಿರುವಂಥ ನಿಮ್ಮೆಲ್ಲರಿಗೂ ಮತ್ತೊಮ್ಮೆ ವಕೀಲ ಪರಿಷತ್ತಿನ ಪರವಾಗಿ ಹಾಗೂ ನಿಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಸ್ವಾಗತವನ್ನು ಕೋರ್ತಾ ನನ್ನ ಎರಡು ಮಾತನ್ನು ಮುಗಿಸ್ತೇನೆ. ಜೈ ಹಿಂದ್.
At the outset, I am very happy and proud to be here today in the memorial lecture of my beloved friend Sri K.N. Puttegowda in his memorial lecture program. I am told that this is the first memorial lecture of Shri K.N. Puttegowda. Chairman of the State Karnataka State Bar Council, Shri S.Mittalakod, and Chairman of the Law Academy, Shri S.F. Goutam Chand, and my beloved friend Shri Kantharaj, Senior Advocate, ex-President of Law Academy, and my senior friends in the bar, and Vice President Vinay Mangalekar of the State Bar Council, and all fraternity members, and ladies and gentlemen. Before going to the subject, I may be permitted to say a few words about my, as I said, beloved friend K.N. Puttegowda. He was a junior to me by 2 years. I got enrolled in the year 1978. If I remember correctly, Puttegowda got enrolled in the year 1980. Since then, so we were very good friends, and we were moving together most of the time. Therefore, I think I can frankly say, though he was a professional, serious professional man, but equally he was a politician. He was interested in politics as well. In fact, he had made, one or two attempts also to get into that field. Somehow he was not able to maybe succeed. Why I am telling this is this. Today's subject, local bodies under the Indian Constitution. Maybe a coincidence. He was also a standing counsel for local body, of course, urban local body for over a period of 25 years. And therefore, I feel that today's subject is dear and near to his heart, because it is relating to both political justice as well as social justice. I will try to explain how, it is political justice and social justice, so far as today's subject is concerned, so later. So therefore, in addition to that, Sri K.N. Puttegowda, as we all know, he was a very active member of the bar, and he was very much concerned with the problems of the advocates, particularly young advocates, and he was pleading before all the forums for the benefit of advocates as a whole. He was in the front. He used to be there, and he used to raise all issues, which are beneficial to the advocates and for the benefit of the good of the profession. So therefore, while doing so, he has also rendered memorable work so far as Advocate Association Bangalore is concerned, and also advocates as a whole throughout the state whenever the issue arises. Therefore, I am really very happy to know that this academy has a program to have a memorial lecture in the name of Mr. Puttegowda. And coming to the subject today, local bodies under the Indian Constitution. To To understand the subject is very, very interesting and important subject also. What we are required to read, what we are required to gather, the importance of the subject is only by reading preamble of the Indian Constitution and part 4 of the Indian Constitution, which is Directory Principles of State Policies, and then part 10, which is dealing with 73rd and 74th Amendment relating to local bodies. These are the relevant, provisions. Preamble, as you know, it is in the preamble itself, in the beginning itself of the Indian Constitution. Directive Principles of State Policy comes under Article 36 to 51. And then 73rd and 74th Amendment, which was inserted by way of constitutional amendment in the year 1992 under Part 10 from Article 243 onwards. So coming to how I said, to understand the subject, we have to go with the preamble, Directive Principles of State Policies, and 73rd and 74th Amendment, Part 10 of the Indian Constitution. Let us see how the preamble is relevant. See, our Indian Constitution, after the adoption on 26 November 1949 in the Constituent Assembly, it has come into force on 26th of January 1950. The Constitution nobody has given to us. See, it is our Constitution. We have resolved as a sovereign republic, we have resolved to have our Constitution, and therefore nobody can have any grievances against the Constitution, because if it is we have made it. If you speak against the Constitution, you are speaking against your own decision. So what we have resolved, you read the Indian Constitution first, to give or to provide justice. What kind of justice? Social, economical and political. Please underline the word political. Our Constitution specifically provides for not only social justice, not only economic justice, but also political. Here, social and political justice are very, very relevant. Whether the provisions under the Indian Constitution relating to local bodies are committed for these two or not is the question now to be examined or to understand. So, the goal of our Indian Constitution is to provide the political justice also. This mostly comes under the political justice. See, what are the local bodies? What is the Panchayat Raj? How the concept originated. in India. See, the moment we say the village administration or Panchayat Raj, which comes under, see, the meaning of local bodies, I think we remember it reminds at least Mahatma Gandhiji, because he pleaded for decentralization of power. He said India is living in villages. In India, there are not less than 6 lakh villages. So the history, coming to the history, before going to the other aspects of the matter, we remember Gandhiji. I will come, what is his contribution, what was his vision about local bodies and Panchayat Raj. One another person is there who is called as the father of the Panchayat Raj. Bhagwan Rai Mehta. Bhagwan Rai was the former chief minister of Gujarat. He was made as the committee chairman in the year 1957. He gave a report that is the basis of Panchayat Raj administration. He gave a report in the year 1957, and very first Panchayat Raj was established in India in the state of Rajasthan in the year 1959, based on Balwant Rai Mehta's report in the year 1957. Since the very system, Panchayat Raj system, was based on the report submitted by Mehta, therefore even today he is called as the father of Panchayat Raj system. Mehta participated in independence struggle. He was purely a Gandhian, well-known Gandhian. He adopted the principle of Panchayat Raj while giving a report based on the vision that Mahatma Gandhi had in the decentralization of power. Throughout, Gandhi argued without any compromise at any stage, saying that one man or one party should not have any power at all. Because, as we all know, the doctrine of Montesquieu's doctrine, you know that. Corrupt, see, absolute power, corrupt, see, absolute, see, corruption will be there when there is an absolute power in one hand, so it will lead to absolute corruption. So therefore, it must be distributed. This was the idea of Mahatma Gandhi. This was adopted by Mehta while giving his report. So that has been, see, used for the purpose of the administration of Panchayat Raj system. So this system was adopted in India, and in fact this system has been accepted because the decentralization of power virtually gives power to the people. that is absolutely needed in a democracy particularly. So our democracy, not merely a democracy, it is called as participatory democracy. Participatory democracy means everybody has to participate in the administration of the state. State includes country also. To give opportunity to participate, to have your own governance. Decentralization is absolutely necessary. And that is a system under which these local bodies, including the Panchayat Raj, is being now used at all levels. Local bodies, we celebrate 1st November as the Day of Local Bodies. In India, we celebrate 1st of November as the Day of Local Bodies. See, local bodies means that includes both urban, that is again classified as urban and rural local bodies. Say, what are urban and rural local bodies? See, municipal corporations, municipal councils, and town panchayats, they comes under the urban local bodies. See, what are rural local bodies? That is the Gram Panchayat, Taluk Panchayat, and district administration, that is the Jilla Panchayat. And this system provides for 3-tier system for the purpose of administration. So this is how it has been, see, this power has been percolated to the people, even to participate, including their election to the body, exercising the power at their level. And here, under this system, government has endowed. See, we must remember that this is local bodies are the law that is going to be made by the state, because this is a state subject. So far as the local bodies laws are concerned, it is a state subject, means state government can make law whatever that is required for the benefit of the people to reach the goal under the preamble to the Indian Constitution, that is political and social justice. You kindly see Article 243G. Article 243G, which provides power to the government to make law, to legislate for the purpose of administration of, say, local bodies, to meet the need of the people at the grassroots level. So government can gift its power to the local bodies, rural local bodies also. So that is how, in fact, to see where was the need for this amendment, that is 73rd and 74th amendment, the question would arise. Kindly see Schedule 11 to the Indian Constitution, which was inserted. Schedule 11 was inserted, see, by virtue of amendment, that is 73rd and 74th amendment, that was passed in the year 1992, given effect to in the year 1993. In fact, again, the 73rd amendment relating to, see, panchayats came into being on 24/4/1993. Again, 24th of April is called as Local Bodies Day. See, and while passing this, they will have to remember Part Part 4 also. Part 4 of the Indian Constitution deals with, as I said, directive principles of state policies. Under the directive principles of state policies, very, very important article is Article 40, which deals with the Panchayat Raj administration. And kindly you can go and see Article 40 and see the history of Article 40 also. Article 40 is based on the dream of Mahatma Gandhi with regard to the village administration. That has been incorporated without using the name of Mahatma Gandhi under Article 40. And we all know that directive principles of state policy is not enforceable as compared to fundamental rights under the Indian Constitution. But remember the importance of directive principles of state policies. I will give you one example. Before the legislatures or in the assembly or in the parliament, if a bill comes for consideration, being a member of the house to oppose the bill or to approve the bill or accept the bill, you must know what are the principles of directive principles of state policy. According to me, if a member of a house, assembly or parliament, if he has understood the principles underlying under the Indian Part 4 Constitution or directive principles of state policies, you will be in a right position to say whether this bill is required or it is in accordance with Indian Constitution or not. Question is, how many people have understood Indian directive principles of state policies? Directive principles of state policies, it is a direction to the government to follow all those principles before making the law. Once Mahatma Gandhi said, before making the taxation law, before imposing taxation, the lawmaker must see the face of a person who is walking on the road in India in barefoot, without any cloth on his body, and fix the tax. So these were the principles uttered by Mahatma Gandhi. And these principles, similarly, several other principles have been incorporated under directive principles of state policies. So far as the Panchayat Raj is concerned, Article 40 is very, very relevant, which says that the power should be given to the people at the grassroots level for the purpose of their benefit. What are all the benefits? You kindly see Schedule 11 of the Indian Constitution. As I said, it was introduced or inserted in the Indian Constitution by virtue of 73rd and 74th Amendment. There in the 11th schedule, all these responsibilities and duties to the Panchayat has been explained. In the area of village health, in the area of infrastructure, in the area of prevention of diseases, in the area of education, particularly at lower level, that is primary and secondary education, all these things will have to be taken care of by the administration in the village level, because they know better what are exactly the problems that they are facing. What are the problems every day they are facing, and they will be in a better position to find out solution for those things. And after this 73rd, 74th Amendment, important thing is, significance of 73rd and 74th Amendment is, after the 73rd and 74th Amendments, what has happened is, so it has provided for Constitution of the Finance Commission, State Election Commission, because local body elections are being managed and conducted by the State Election Commission. You know, there are Central Election Commission as well as State Election Commission. It is the duty or within the purview of the State Election Commission to see that elections are being held to the local bodies as provided under the either specifically under the Constitution or under the enactment or a statute made under the Indian Constitution. Then the question would arise, was there not a Panchayat Raj or three-tier system was not in existence earlier to 73rd and 74th Amendment, that is earlier to 1993. It was there, as we all know, earlier Panchayat Raj and Local Bodies Act was there. Later in the year 1993, Act came, Jilla Parishad, Taluk Panchayat and Gram Panchayat Samitis Act, etc. And later it was again amended. Panchayat Raj Act came. Now Swaraj, Gram Swaraj and Panchayat Raj Act is the latest one. So this has been amended as provided under 73rd and 74th Amendment. 73rd Amendment is relating to Panchayat Raj and 74th Amendment is relating to municipalities. That is urban local bodies. See, then when there was already law with regard to the administration of local bodies, where was the need for 73rd and 74th Amendment? You can ask me. The need is, first thing is, by virtue of 73rd and 74th Amendment, constitutional status has been given to the local bodies, recognized under the Indian Constitution. One point, and next point is to give more powers, more systematic, and to make the administration committed by the provisions provided under the 73rd and 74th Amendment. For example, regular elections were not there. Fund distribution was not as required by the village bodies. All those things have been now provided. There is an improvement in the administration. There is a commitment on the part of the state government by virtue of 11th schedule to provide the required finance to the Panchayat Raj and municipal administration. And power is given to them only for the purpose of using the fund given by the government. 73rd and 74th Amendment has provided reservation for scheduled caste, scheduled tribes. Women reservation is there, and also other backward classes. See, who are all other backward classes? Those who are not scheduled caste and scheduled tribe are all other backward classes. So for all these categories, scheduled caste, scheduled tribe, women and other backward classes, earlier there was no reservation to the extent now given under the 73rd Amendment. Initially it was given 1/3 reservation for women. Now it has been made in our state 50%. Both for membership as well as office bearers, that is Adhyakshas of Taluk Panchayat, Gram Panchayat and Jilla Panchayat. So these provisions were not there at all. And this has been made on the principle of social justice. What is social justice? I will give an example. that does not require any deep examination or deep study to understand what is social justice. Social justice means, take example, see, this country is one family. Illustration, one family. So we are all members of that family. And all assets in this country belongs to that family. So as it is being done in the partition, you divide it equally to everybody. That is all chief justice. That is all social justice. Has it been done? Property means not landed property alone. In the field of education, in the field of employment, in the field of political rights, representation. So has it been, given, those assets have been given equally to everybody in this country? No. Therefore, this social justice is to be rendered as provided under the Indian Constitution preamble, because preamble is the goal which has to be achieved by implementation of all other provisions of the Indian Constitution. So, to meet the requirement of social justice, all these reservations have been provided under the 73rd and 74th Amendment, which was not there earlier under the statutes made for the purpose of running the panchayats and municipal administration. So, there is an improvement that was required when it was not being done properly, and to see that it is done properly and to give more powers for the purpose of administration at the grassroots level. That was the reason why 73rd and 74th Amendment were, inserted under the Indian Constitution by giving specific duties and responsibilities to the local bodies under Schedule 11. And as I said, unless you allow the people to participate, unless you allow the people to say that your administration is not correct, if Bar Council is not running properly, if a state Bar Council is not working in the interest of the advocates, for which purpose it has been established in the year 1961, standing in Bar Council only, I can comment saying that Bar Council is not doing correctly. If I am not allowed to say that, there is no democracy at all. Again I am quoting Mahatma Gandhi. Mahatma Gandhi ji said, in a democracy, if you have no right to say that democracy, the system of governance under the democracy is not correct, it is not a democracy at all. Democracy means every person who is living under the system has got right to make his own comments. Of course, it must be fair comment. So that is how, therefore our democracy is called as participatory democracy. You kindly see the Right to Information Act. What is the object? Under the Right to Information Act, Information Act has been made, of course it is a judge-made law. After the Supreme Court judgment saying that right to information is a fundamental right enshrined under Article 19, when Supreme Court said so, then Government of India made that law, that is Right to Information Act. Right to Information Act is a central law. And under the preamble to the Right to Information Act, it has been made very clear. That act has been made, one, for the purpose of preventing the corruption, and the other one is giving right to the public to know what is going in the state administration or the Government of India administration. A taxpayer is entitled to know how his money is being utilized by the government. If nobody is disclosing correctly, you have got right to file an application saying that I want that information. Under the Act, it is defined what is information. If it comes, your claim comes within the purview of the information, according to the definition of the Right to Information Act, you are entitled for the information in writing. That is the importance of Right to Information Act. Because you have to know that, you have to participate. Ours is participatory democracy. That is the principle on which that enactment has been made. And that applies to everywhere in the democracy. That is how, for the purpose of to give the right to participate, right to contest election, right to say this is right, this is not right as an elected person. And these powers have been given to the village panchayat level. So you have self-governance. This is the principle. Thereby, so distribution of power, decentralization of power. And this is the idea with which these systems have been made. So a 3-tier system is there, and powers have been given independently. They can exercise their powers, they can contest, they can administer their own problems. So this is how it is being done. Now in the absence of local bodies, what would happen? Either state government will have to exercise the powers in Bangalore, or government of India will have to exercise its power over a village in Delhi. So that is not correct. So that is how the system is being worked now. And what is the purpose of, to understand this one, I can say what exactly the Supreme Court has said about 73rd and 74th Amendment, and also local bodies also. So I can give you the judgment also with regard to that. Kindly see, it is I can give 2 judgments. That is one 2012 Supreme Court. Yes, AR 2012 Supreme Court 2697. Village Panchayat Kalangute, CALANGUTE, Kalangute versus Additional Director of Panchayat 2, Roman 2. This is a judgment which has explained right from preamble to the 73rd and 74th Amendment, how it is required, how it is in consonance with the preamble to the Indian Constitution system. And then one more judgment after 73rd, 74th Amendment, that is 2010, Part 7 SCC, page 202. That is Krishnamurthy versus Union of India, from Karnataka state only. So far significance of this Krishnamurthy case is concerned. I think you might have already seen the report submitted by Justice Bhaktavatsala, that is regarding reservation in politics or elections. The distinction made in this judgment is, till this Krishnamurthy's case judgment rendered by the Honorable Supreme Court, what was the position? So the reservation was decided even for election purposes under the principles underlined under Article 15.4 and 16.4 of the Constitution. Article 15.4 deals with the reservation in the educational field. 16.4 deals with the employment. So where it is provided saying that who is backward backward is entitled for reservation under 16.4 and 15.4. Who are backward classes? According to 15.4 and 16.4, who are educationally and socially backward. That is the yardstick that is being applied to give reservation under 15.4 and 16.4. 15.4 deals with the reservation for the purpose of education. 16.4 deals with for the purpose of reservation in employment. For the first time in 2010, in Krishnamurthy's case, Supreme Court made a distinction saying that the principle applicable for the purpose of reservation for education under 15.4 and 16.4 employment is not applicable to the reservations in elections. There must be reservations in elections also, it is true, but the principle should be different. Yardstick should be different. So therefore, a commission constituted for the purpose of deciding the reservation under 15.4 and 16.4 is not sufficient for the purpose of making reservation for elections. So what should be done? So Supreme Court for the first time said, for the purpose of making reservation for elections, a separate commission is to be dedicated. Their word used is dedicated commission is to be constituted. Therefore, in Karnataka, for the purpose of making this election now ensuing election, that committee by Justice Bhaktavatsal was constituted. A report was received. Now, based on that report only, now reservations are being made for the purpose of conducting in the coming elections for local bodies. So, therefore, for providing reservation, a separate commission is to be made. Commission report is to be obtained by the government. For better administration, we have to give reservation for the local bodies also, and that factor who is politically backward. This commission will have to decide who is politically backward. To decide that also, you have to ascertain the empirical data with regard to the political backwardness, not socially and educationally. That is for 15.4 and 16.4. So therefore here, a commission is to be constituted. They will have to obtain empirical data to examine a particular community or a particular section in the society, whether they are politically backward or not. What are the requirements? You get the empirical data. What is the meaning of empirical data? Empirical data is nothing but data regarding population, data regarding backwardness, social backwardness, political backwardness, and whatever data you get that must be supported by some material, then it is called empirical data. Without any evidence or without any supporting material, you cannot call a data as an empirical data. That is a distinction. How to ascertain political backwardness? You have to take the history of that community as a whole, because individual family cannot be a basis for the purpose of making reservation. Class, word used is class. Whether that class politically backward or not, so how many times they contested in the panchayat elections, how many times they contested in the Jilla Panchayat election, how many times they contested in the town panchayat, how many times they contested in the municipal, how many times they became presidents, vice president or office bearers, how many times they got a seat in the members of legislative assembly election, parliament. All these things will have to be ascertained. How many times that class has got the benefit of reservation or opportunity to get into the house, either in the parliament or in the state level legislature. All those things will have to be ascertained, and after coming to know of them by way of getting the data, then only you can decide whether that particular class is politically backward or not. So based on that, this criteria is to be decided. Therefore, crux of the Krishnamurthy's case is that criteria for the purpose of making reservation under 15.4, 16.4 and also political reservation should not be common, it should be separate. That is the law laid down for the first time in Krishnamurthy's case in 2010. And that is only for the purpose of making reservation in local bodies, that is political reservation. That is nothing but reservation in political, local bodies and assembly, parliament is nothing but political reservation. That is the distinction made, and that has been made only for the purpose of saying that the person who did not get the opportunity to contest and get elected and participate in the democracy or in the governance, that provision has been made. So all these powers were not earlier, so before the amendment, 73rd and 74th amendment, all things have been provided. Earlier, no finance commission was there in the state. No state election commission was there in the state. Now these powers to conduct election to these local bodies are within the purview of the state election commission only. And these powers have been introduced by virtue of the 73rd and 74th amendment. Therefore, by reading together, that is the preamble, director principle of state policies and 73rd and 74th amendment plus 11th schedule. Kindly see the 11th schedule, what it says, the powers, it is listed, so many powers have been given to the panchayat. All those powers have been, endowed, if I use the word correct, endowed, that is gifting. Government is gifting those powers to the panchayat. Panchayat can exercise it. What is relevant, what is not relevant. So that is how. Virtually now you can see that the 73rd and 74th amendment, virtually I call it as a social revolution. Social revolution means it not only provides for the reservation, that is the participation of the persons who did not get the opportunity for participation, either scheduled caste, scheduled tribe, women or other backward classes, now it is providing. That is what is called social justice. And it is, so therefore, it is a revolutionary step taken by the government of India while making these constitution amendments. And I say, our constitution, as you all know, though it is a static, document is static, but constitutionalism is not static. I am trying to make the distinction. Constitution is a static document. I agree. But constitutionalism is not static. Constitutionalism is like a growing tree. According to me, but for the Article 368 under the Indian Constitution, I think our Constitution would not have survived till now. That is a very, very, intelligence way of doing the Constitution, because even after 77 years now, or 79 years now, you see our Constitution has survived because of this Article 368. Because you all know legal, persons, you can understand, it provides for changing the Constitution according to need in the society. Kindly imagine if there was no Article 368 or there was no provision for making the changes in the Indian Constitution as required in the society, certainly Constitution would have been thrown out. So that is the importance, that is the significance of Article 368. It comes to the aid of the people who are really in need of change in the Constitution. So But for that, see, definitely Constitution would not have survived till now, and it is because of 368 we got 73rd and 74th Amendment, and whatever that is required, see, we can get by way of amendment, of course. It should not, whatever amendment you need, you can, but there is a limit for that also, within which it will have to come. That means you can't violate basic structure of the Indian Constitution. Basic structure of the Indian Constitution. See, what is basic structure again? Kindly see. What is basic structure means, what is human right? What is fundamental right? So in my opinion, what is fundamental right, human right and basic right means, see, without which, a right without which you can't lead a normal life in the society. Nobody can prevent air into this hall, because if there is no air, we can't survive. If there is no, see, good drinking water or clean drinking water, so you can't survive. Yeah, what would have happened if there was no separation of powers? Separation of powers, if there is no separation of powers, government would have exercised the power of making law, they would have exercised the power of execution also, they would have exercised the power of judiciary also. If one man had all those powers, where would have been? Can you expect justice from the hand of a person who is exercising absolute power? Now, legislature makes law. Execution, see, implement the law made by the legislature. And if there is any flaw in the law, if there is any mistake in the law, then, or if there is any mistake in the, see, implementation of law by the executive, then the judiciary can, say, interfere because of their separate power given under the Indian Constitution. That is what, see, our Article 246 says. 246 specifically says, so what are the laws that can be made by Government of India, and that the law that can be made by the state government, and what are the subjects on which both state as well as central government can make law, and where the central government can override the powers of the state government. Of course, there also the principle of federalism will have to be obeyed or observed. So these are all, see, you suppose if there is no federalism, that is the basic structure. If that goes, see, who will, see, question, see, who will answer to your questions by the state? You can't interfere, you can't curtail the powers of the state government. That is the principle under the federalism. Principle of federalism. See, our system is a federal system. So all these powers, under those things only, see, we got this system of, see, Panchayat Raj. See, Panchayat Raj includes both urban and local. See, urban and local administration is there up to the district level. The three-tier system has been made for the purpose of convenience, giving power to the people. This is, therefore, both social justice as well as the political justice as enshrined under, as provided under the preamble, has been provided under both Directive Principle of State Policies as well as 73rd and 74th Amendment. And this is a system which is being, adopted throughout India for the convenience of the people at village level also. So therefore, that is what, according to me, this local bodies principle is purely, though it is not specifically mentioned, based on the vision Mahatma Gandhi ji had in the village administration. Self-governance. So the principle underlined under these amendments and Directive Principle of State Policies, Article 40, as well as the preamble, it is totally based on the principle of self-governance and also principle of participatory democracy, both politically, socially, as well as economically as well. So therefore, these are the things which have to be understood by everybody, because Article 51 capital A says that we are expected to know and we are not expected to violate any one of the provisions of the Indian Constitution. Here, Constitution is there, and in the Constitution there is basic structure in the Constitution now which has been made in the Fundamental Rights case in the year 1973, and subsequently barring basic structure principles, any other law can be done under the Indian Constitution. And one such law now it has been made is 73rd and 74th Amendment. Now it is being worked out for the purpose of giving rights to the people as provided under the Indian Constitution preamble. Therefore, my submission to this respectful audience is, this is absolutely necessary to know. This is purely based on the goal reached under the preamble to the Constitution, and also to meet the justice according to the Directive Principles of State Policy, and also the participation given to the grassroots level as participatory democracy defined the participation. So for having given this opportunity to speak on local bodies under the Indian Constitution, I am grateful to the Karnataka State Bar Council and also this Belko program. And one and all, thank you very much.
On powers, obligations, purely on the subject of local bodies under Constitution, Sir has given us the comprehensive view. ಈ ಆಯುರ್ವೇದಿಕ್ ಹೇಳ್ತಾರಲ್ಲ, ಗೋಯಿಂಗ್ ಟು ದಿ ರೂಟ್, ವೈ ದಿಸ್ 73rd amendment, 74th amendment were brought in, the distinction between Article 15.4, 16.4, the reservation under 15.4, 16.4 and the reservation under local bodies. From the preamble to part 4 to part 10, then coming back to part 3, then highlighting the aspect of Article 51A. Thank you so much, sir. You have covered, if I am not wrong, almost Constitution in such a short time. Thank you very much, sir.
ನಮ್ಮ ಸ್ಪೀಕರ್ ಆದಂಥ ಎಚ್ ಕಾಂತರಾಜ್ ಅವರೇ, ಹಾಗೂ ನಮ್ಮ ಬಾರ್ ಕೌನ್ಸಿಲ್ನ ಉಪಾಧ್ಯಕ್ಷರಂಥ ಮಂಗಳೇಕರ್ ಅವರೇ, ಹಾಗೂ ಲಾ ಅಕಾಡೆಮಿ ಚೇರ್ಮನ್ರಾದಂಥ ಗೌತಮ್ ಚಂದ್ ಅವರೇ, ಸೀನಿಯರ್ ಕೌನ್ಸಿಲು ಹಾಗೂ ನಮ್ಮ ಲಾ ಅಕಾಡೆಮಿಯ ಸದಸ್ಯ ಅಂತ ಬಸವರಾಜ್ ಅವರೇ, ಹಾಗೂ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಸದಸ್ಯರಾದಂಥ ರಾಜಣ್ಣ ಅವರೇ, ಲಾ ಅಕಾಡೆಮಿ ಮಹಿಳಾ ಪ್ರತಿನಿಧಿಯಾದಂಥ ಪೂರ್ಣಿಮಾ ಅವರೇ, ಹಾಗೂ ಬೆಂಗಳೂರು ಅಸೋಸಿಯೇಷನ್ ಪದಾಧಿಕಾರಿಗಳೇ, ಹಾಗೂ ಇಲ್ಲಿ ಸೇರಿರ್ತಕ್ಕಂಥ ಎಲ್ಲ ನನ್ನ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲ ಪರಿಷತ್ತಿನ ಸ್ಟಾಫ್ ಹಾಗೂ ಕೋಆರ್ಡಿನೇಟರ್ ಆದಂಥ ಕನಕರಾಜ್ ಅವರೇ, ಹಾಗೂ ನಮ್ಮ ಈ ಆನ್ಲೈನ್ ಕಾರ್ಯಕ್ರಮ ನೋಡ್ತಕ್ಕಂಥ ಇಡೀ ರಾಜ್ಯದ ಎಲ್ಲ ವಕೀಲ ಬಂಧುಗಳೇ ಹಾಗೂ ಪದಾಧಿಕಾರಿಗಳೇ ಹಾಗೂ ಸಾರ್ವಜನಿಕರೇ, ಈಗಾಗಲೇ ನಮ್ಮ ಪುಟ್ಟೇಗೌಡರ ಬಗ್ಗೆ ಎರಡು ಮಾತಾಡಲೇಬೇಕಾಗತ್ತೆ ನಾನು. ಯಾಕಂದರೆ ನಾನು 2011 ಪ್ರಪ್ರಥಮ ಬಾರಿಗೆ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಚುನಾವಣೆ ನಿಂತಿದ್ದೆ. ಆವಾಗ ಅವರು ಬೆಂಗಳೂರು ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ನ ಅಧ್ಯಕ್ಷ ಆಗಿದ್ದು, ಈಗಿರ್ತಕ್ಕಂಥ ನಮ್ಮ ರಾಜಣ್ಣವರು ಸೆಕ್ರೆಟರಿ ಅವರಾಗಿದ್ದರು. ನಾನು ಅವತ್ತೊಂದು ಕನಸು ಕಂಡಿದ್ದೆ, ಇಡೀ ರಾಜ್ಯದಲ್ಲಿರ್ತಕ್ಕಂಥ ಎಲ್ಲ ಒಂದು ವಕೀಲರ ಒಂದು ದೂರವಾಣಿ ಕೈಪಿಡಿ ಮಾಡ್ಬೇಕಂತ, ಎನಿ ಟೈಮ್ ಬನ್ನಿ ನಾವು ಮಾಡ್ತೀವಿ ಅನ್ನೋಂಥ ಮಾತನ್ನು ಹೇಳಿದರು. ಎಷ್ಟೇ ಸಾರಿ ನಾವು ಫೋನ್ ಮಾಡಿದ್ರು ಅದನ್ನು ರಿಸೀವ್ ಮಾಡಿದ್ರು ಅವರು. ಆ ದೃಷ್ಟಿಯೊಳಗೆ ಅವ್ರು ನೆನೆಸ್ಬೇಕಾಗತ್ತೆ. ಅವ್ರು ತೀರ್ಕೊಂಡ ನಂತರ ಅವ್ರ ಮನೆಗೆ ಹೋದಾಗ ಅವರ ಜೀವನ ಚರಿತ್ರೆಯನ್ನು ಕೇಳಿ ನನಗೆ ರೋಮಾಂಚನ ಆಯಿತು. ಅವ್ರದ್ದೊಂದು ಪುಟ್ಟೇಗೌಡದೊಂದು ಬುಕ್ ಬರೆದಿದೆ. ಆ ಬುಕ್ಕನ್ನು ತಾವೆಲ್ಲರೂ ಓದಬೇಕಂತ ಕೇಳ್ತಾ, ಇವತ್ತಿನ ನಮ್ಮ ರಾಜ್ಯದ ಎಲ್ಲ ವಕೀಲರಿಗೂ ಲೋಕಲ್ ಬಾಡಿ ಬಗ್ಗೆ ನಮ್ಮ ಸವಿಸ್ತರವಾಗಿ ಮಾಡಿದಂಥ ಕಾಂತರಾಜ್ ಅವರಿಗೆ ನಾವು ಯಾವಾಗಲೂ ಅಭಿನಂದನೆ ಸಲ್ಲಿಸ್ತೀವಿ. ಯಾಕಪ್ಪ ಅಂದ್ರೆ ಅವರು ನಾವು ಯಾವುದೇ ಕೆಲಸ ಕೇಳಿದ್ರು ಇಲ್ಲ ಅನ್ನುವಂಥ ಮಾತೇ ಇಲ್ಲ, ಅಷ್ಟೇ ಸರಳ ಸಜ್ಜಿಕೆಯಿಂದ ಇದ್ದಾರೆ. ಆ ದೃಷ್ಟಿಯೊಳಗೆ ಇವತ್ತಿನ ದಿವಸ ಲಾ ಅಕಾಡೆಮಿಯವರು ಈ ಕಾರ್ಯಕ್ರಮನ ಆರ್ಗನೈಸೇಷನ್ ಮಾಡಿದ್ದಾರೆ. ಲಾ ಅಕಾಡೆಮಿಯ ಎಲ್ಲ ಸದಸ್ಯರಿಗೂ ಸಹ ಹಾಗೂ ರಾಜ್ಯದ ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮವನ್ನು ವೀಕ್ಷಣೆ ಮಾಡ್ತಕ್ಕಂಥ ಎಲ್ರಿಗೂ ಸಹ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ ಪರವಾಗಿ, ರಾಜ್ಯದ ಎಲ್ಲ ವಕೀಲರ ಪರವಾಗಿ ನಾನು ಅಭಿನಂದನೆ ಸಲ್ಲಿಸ್ತೀನಿ. ಎಲ್ಲ ವಕೀಲರು ಸಹ ಇನ್ನು ಮುಂದಿನ ದಿನಮಾನದಲ್ಲಿ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಫೇಸ್ಬುಕ್ KSBC.org ವೆಬ್ಸೈಟನ್ನು ಹಾಗೂ ಯೂಟ್ಯೂಬನ್ನು ನೋಡಿ ನಮ್ಮ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿಗೆ ಮೆರುಗು ತಂದು ಕೊಡಬೇಕಂತ ಕೇಳಿಕೊಂಡು ನನಗೆ ಅಧ್ಯಕ್ಷೀಯ ಭಾಷಣ ಮಾಡಲಿಕ್ಕೆ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಂಥ ಲಾ ಅಕಾಡೆಮಿ ಸರ್ವ ಸದಸ್ಯರಿಗೂ ಹೊಂದಿಸಿ ನಾನು ಎರಡು ಮಾತನ್ನು ಮುಗಿಸ್ತೀನಿ. ಧನ್ಯವಾದ.
Now I request Mr. S.Mittalakod sir to give a presidential speech. I request Mr. Rajana, member KSBC, to deliver a speech.
ಎಲ್ಲ ಗಣ್ಯರೇ ಮತ್ತು ಸ್ನೇಹಿತರೆ, ನನಗೆ ಪುಟ್ಟೇಗೌಡರ ಬಗ್ಗೆ ಮಾತಾಡಲಿಕ್ಕೆ 2 ದಿನ ಮಾತಾಡೋಷ್ಟು ಮಾಹಿತಿ ನನ್ನ ಹತ್ರ ಇದೆ. ಆದರೂ ನಾನು 1 ನಿಮಿಷದಲ್ಲಿ ಮುಗಿಸ್ತೀನಿ, ಟೈಮ್ ಭಾಳ ಅಭಾವ ಇದೆ. ಪುಟ್ಟೇಗೌಡರ ಜೊತೆ ಕೆಲಸ ಮಾಡಿದಂಥ ಪುಣ್ಯ ನನಗೆ ಬರಬೇಕು. ಯಾಕಂದರೆ ನಾನು ಅವರು ಸಾಮಾನ್ಯವಾಗಿ ಯಾವುದೇ ವಿಚಾರ ಬಂದಾಗ ವಕೀಲರ ಹಿತ ಕಾಪಾಡಬೇಕು, ವಕೀಲರ ಸಂಘ ಉಳಿಬೇಕು ಮತ್ತು ಹೈಕೋರ್ಟ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಉಳಿಬೇಕು ಅನ್ನೋದರಲ್ಲಿ ಅವರು ನಂಬರ್ 1. ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಕಾಂಪ್ರಮೈಸ್ ಆಗ್ತಿರಲಿಲ್ಲ ಮತ್ತು ಯಾರ ಮಾತು ಕೇಳ್ತಿರ್ಲಿಲ್ಲ ಅವರು, ಎಕ್ಸೆಪ್ಟ್ ನನ್ನ ಮಾತು ಬಿಟ್ಟು. ಯಾಕಂದರೆ ಅವರು ನಾನೊಂದು 2 ದಿನ ಮಾತಾಡ್ತಿರಲಿಲ್ಲ. ಅವರು ಏನಾರ ಸ್ವಲ್ಪ ತಪ್ಪು ಮಾಡ್ತಿದ್ರು. ಅವರು ಭಾಳಷ್ಟು ತಪ್ಪು ಮಾಡೋರು. ಅಂದರೆ ಯಾರೋ ರೇಗ್ ಬಿಡೋದು, ಎಂಪ್ಲಾಯೀಸ್ಗೆ ಜಡ್ಜಸ್ ಮೇಲೆ ರೇಗ್ ಬಿಡೋದು, ಆ ಥರದ್ದೆಲ್ಲ ಮಾಡ್ತಿದ್ರು. ಭಾಳಷ್ಟು ಇಶ್ಯೂ ಇದ್ವು ಅವರು ನಮ್ಮಲ್ಲಿ. ಆಗ ಅದೇನು ಹೇಳ್ತಾರಲ್ಲ, SM ಕಟ್ನಿಗೆ ಬಂದಂಥ ಎಲ್ಲ ಕಷ್ಟಗಳು ನಮಗೆ ಬಂದಿದ್ವು ಅವಾಗ. ದಿನಕರನ್ ವಿಚಾರ ಇರ್ಬೋದು, ಬೇರೆ ಬೇರೆ ವಿಚಾರಗಳಿದ್ದಾಗ ಒಬ್ಬ ಚೀಫ್ ಜಸ್ಟಿಸ್ ವಿರುದ್ಧ ಹೋರಾಟ ಮಾಡೋದಂದರೆ 1 ವರ್ಷದ ಕಾಲ ಅವ್ರನ್ನ ಕೂತ್ಕೊಳ್ಳೋಕೆ ಬಿಡದೇ ಇರತಕ್ಕಂಥ ಒಂದು ವಾತಾವರಣ ಕ್ರಿಯೇಟ್ ಆಗಿತ್ತು, ಸೆಪ್ಟೆಂಬರ್ ಟು ಸೆಪ್ಟೆಂಬರ್. ಆಗ ಭಾಳಷ್ಟು ಕಷ್ಟ. ಅಂಥ ದಿನಗಳಲ್ಲಿ ಅವ್ರೇನಾರು ಒಂದು ಸಣ್ಣ ತಪ್ಪು ಮಾಡಿದ್ರೆ ನಾನು 2 ದಿನ ಅವ್ರ ಹತ್ರ ಮಾತಾಡ್ತಿರ್ಲಿಲ್ಲ. ಅವರು ನನ್ನ ಕಾರಲ್ಲಿ ಅಥವಾ ಅವ್ರ ಕಾರಲ್ಲಿ ಕೂರಿಸ್ಕೊಂಡು ಹೋಗ್ತಿದ್ರು. ಏನಪ್ಪ ಮಾತಾಡ್ತಿಲ್ಲ, ಏನು ಸಮಾಚಾರ ಅಂದ. ಇಲ್ಲ ಸರ್, ಈ ಥರ ನೀವೇನೋ ಮಾಡಿ ತಪ್ಪಂತ ಅನ್ನಿಸ್ತಿಲ್ಲ ನನಗೆ, ತಪ್ಪಾಯಿತು, ಭಾಳ ಬೇಜಾರಾಯಿತು ನನಗೆ, ಆ ಥರ ಮಾಡೋದು ನೀವು ಅಂತ. ಆಯ್ತು ಬಿಡಪ್ಪ, ನಿಂದೊಂದು ಕಥೆನಪ್ಪ ನಿಂದು, ಆಯ್ತು ಬಿಡಿ ಏನೋ ಮಾಡೋಣ ಅಂತ. ಅವರು ಬೆಂಗಳೂರು ವಕೀಲರ ಸಂಘಕ್ಕೆ ಅವರು ಗವರ್ನಿಂಗ್ ಕೌನ್ಸಿಲ್ ಮೆಂಬರ್ ಆಗಿದ್ದರು, ಟ್ರೆಸರರ್ ಆಗಿದ್ದರು, ಜನರಲ್ ಸೆಕ್ರೆಟರಿ, 2 ಟರ್ಮ್ ಜನರಲ್ ಸೆಕ್ರೆಟರಿ ಅವರು, ಮತ್ತು 1 ಟರ್ಮ್ ಪ್ರೆಸಿಡೆಂಟ್ ಆಗಿದ್ದರು. ಮತ್ತು ಇವತ್ತೇನಾದ್ರು ಸೊಸೈಟಿ ಭಾಳಷ್ಟು ದೊಡ್ಡ ಲೆವೆಲ್ಗೆ ಒಂದು 200-300 ಕೋಟಿಯಷ್ಟು ಆಸ್ತಿಯನ್ನು ಹೊಂದಿದೆ ಅಂದರೆ ಅದಕ್ಕೆ ಪುಟ್ಟೇಗೌಡರು ಕಾರಣ. ಕಂಪ್ಲೀಟ್ ಸುಟ್ಟೋಗಿದ್ದಂಥ ಒಂದು ಸಂಸ್ಥೆಯನ್ನು ಮತ್ತೆ ಹುಟ್ಟಾಕಿದಂಥ ಅವರು, ಅದಕ್ಕೆ ಪಯಂದಿರೋದು ತಪ್ಪಾಗಲಾರ್ದು, ಅದಕ್ಕೆ ಪಿತಾಮಹನೇ ಅವರು. ಆದರೆ ಒಂದು ಆಶ್ಚರ್ಯ ಅಂದರೆ ಅವರು ಪ್ರೆಸಿಡೆಂಟೇ ಆಗಲಿಲ್ಲ ಸೊಸೈಟಿಗೆ ಕಡೆವರೆಗೂ, ಬರೀ ಡೈರೆಕ್ಟ್ರಾಗಿ ಉಳ್ಕೊಂಬಿಟ್ರು. ಅವಳು ಯಾವಾಗಲೂ ಹೇಳೋರು ಅವರು ನನಗೆ, ನಾನು ಬೆಂಕಿ ಜೊತೆ ಇದ್ದ ಕೆಂಡಾಗಿ ಉಳ್ಕೊಂಬಿಟ್ನಪ್ಪ, ಕೆಂಡ ಆಗಲೇ ಎಲ್ಲ ಬರೇ ಇದ್ಲಾಗಿ ಉಳ್ಕೊಂಬಿಟ್ನಲ್ಲಪ್ಪ. ಇವತ್ತು ಸಣ್ಣ ಹುಡುಗರೆಲ್ಲ ಸೊಸೈಟಿ ಅಧ್ಯಕ್ಷರು ಮಾಡಿದ್ದೀವಿ ನಾವು, ನಮ್ಮ ಸಿಂಡಿಕೇಟೇ ಗೆದ್ದಿದೆ, ಬಟ್ ಅವ್ರು ಮಾತ್ರ ಪ್ರೆಸಿಡೆಂಟ್ ಆಗಿರಲಿಲ್ಲ. ಮತ್ತು ಬ್ಯಾಂಕಿಗೂ ಅಷ್ಟೇ, ಇವತ್ತು 1,000 ಕೋಟಿಯಷ್ಟು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಮಾಡ್ತಿದ್ವಿ ಬ್ಯಾಂಕು, ಅದನ್ನು ಕಟ್ಟಿದ್ದೆ ಅವರು, ಬಟ್ ಅವರು ಪ್ರೆಸಿಡೆಂಟ್ ಆಗಲಿಲ್ಲ ಬ್ಯಾಂಕಿಗೆ. ಆಗಲಿಲ್ಲ, ಅವಕಾಶನೇ ಸಿಗಲಿಲ್ಲ ಅವರಿಗೆ. ಯಾರನ್ನೋ ನೀನಾಗೋ ಅಂತ ಹೋಗ್ತಿದ್ರು, ಆ ಥರ ಅವರು. ಮತ್ತು ಹಾನೆಸ್ಟ್ ಟು ದಿ ಕೋರ್, ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ನ್ಯಾಯಾಧೀಶರು ನೇರವಾಗಿ ನನ್ನ ಕಣ್ಣಾರೆ ಚೇಂಬರ್ಗೆ ಹೋಗಿ ನೀವು ತಪ್ಪು ಮಾಡ್ತಾಯಿದ್ದೀರಾ. ನನಗೆ ಒಂದು ನೆನಪಿದೆ, ಒಬ್ಬ ಹೈಕೋರ್ಟ್ಗೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜು ಬಂದಾಗ ಒಂದು ಚೇಂಬರ್ಗೆ ಹೋಗಿ ಹೇಳಿದ್ರು ಅವರು, ಸರ್ ನಿಮ್ಮ ಮೇಲೆ ಭಾಳ ಅಲಿಗೇಷನ್ ಇದೆ ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ ಇದ್ದಾಗ, ಆ್ಯಕ್ಚುಲಿ ನೀವು ಹೈಕೋರ್ಟಿಗೆ ತರಲೇಬಾರ್ದಾಗಿತ್ತು, ನಿಮ್ಮನ್ನು ತಂದುಬಿಟ್ಟಿದ್ದಾರೆ ಏನೋ ಗೊತ್ತಿಲ್ಲ, ಇನ್ಮೇಲೆ ಅಂಡರ್ ದಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ನಿಮ್ಮನ್ನು ಪರ್ಮನೆಂಟ್ ಆಯಿತು ಅಂದರೆ 2 ವರ್ಷ 3 ವರ್ಷ ನಿಮ್ಮನ್ನು ತೆಗಿಯೋಕ್ಕೆ ಆಗೋದಿಲ್ಲ, ಅಂಥ ಒಂದು ವ್ಯಕ್ತಿತ್ವ ಇರ್ತಕ್ಕಂಥ ಒಂದು ಸ್ಟೇಟಸ್ ಇರ್ತಕ್ಕಂಥ ಒಂದು ಪೋಸ್ಟ್ ಅದು. ಇನ್ಮೇಲೆ ಆದರೂ ಕೈ ಬಾಯಿ ಶುದ್ಧ ಇಟ್ಕೊಳ್ಬೇಕು, ನಾನು ಇವತ್ತು ಹೇಳ್ತಿದ್ದೀನಿ ನಾನು ಅಂತ ನೇರವಾಗಿ ನನ್ನ ಕಣ್ಮುಂದೆ ಹೇಳಿದ್ದು ಅದು. ಅವರು ನಿಜವಾಗ್ಲೂ ಹೇಳ್ತೀನಿ, ಪುಟ್ಟೇಗೌಡರಿಗೆ ಅವರು ಕೈ ಹಿಡ್ಕೊಂಡು ನಮಸ್ಕಾರ ಮಾಡಿಬಿಟ್ರು. ಸಾರಿ ಪುಟ್ಟೇಗೌಡ, ನನ್ನದೇನು ತಪ್ಪು ಮಾಡಿದ್ರೆ ಕ್ಷಮಿಸ್ಬಿಡು, ಇನ್ನು ಕರೆಕ್ಟಾಗಿ 2 ವರ್ಷ 3 ವರ್ಷ ಇದೆ ಸರ್ವಿಸ್, ಆರಾಮಾಗಿರ್ತೀನಿ ನಾನು. ಆ ಥರ ಮನುಷ್ಯ. ದಿನಕರನ್ ವಿಚಾರದಲ್ಲಿ ಒಂದೇ ಒಂದು ಕಾಂಪ್ರಮೈಸ್, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಚೇಂಬರ್ ನಾನು ನೋಡಿಲ್ಲ, ಒಂದೇ ಸಾರಿ ನಾನು ನೋಡಿರೋದು. KG ಬಾಲಕೃಷ್ಣ ಅವರು ಚೀಫ್ ಜಸ್ಟಿಸ್, ಅವರ ಚೇಂಬರ್ಲಿ ಕೂತ್ಕೊಂಡಾಗ ಸಿರಿಯಾಕ್ ಜೋಸೆಫ್, ರವೀಂದ್ರನ್ ಇಬ್ಬರು ಚೀಫ್ ಜಸ್ಟಿಸ್, ಅವರಿಬ್ಬರು ಜಡ್ಜ್ಗಳು ಚೀಫ್ ಜಸ್ಟಿಸ್ ಕೂತಿದ್ರು. ಇಲ್ಲ ನೀವೇನಾದ್ರು ಮಾಡಿ ದಿನಕರನ್ನ ಕೂತ್ಕೊಳ್ಳೋಕೆ ಬಿಡಿ, ಅಟ್ಲೀಸ್ಟು ಒಂದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋಕ್ಕಾದ್ರೂ ಒಂದು ಕೋರ್ಟ್ ಇರುತ್ತೆ, ಒಂದು ಎಲ್ಲ ಮ್ಯಾಟ್ರಸ್ ಹಾಕ್ಕೊಳ್ತಾರೆ ಅವರು, ಫಸ್ಟ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟ್ರಿಗೆ ಬಿಡಿ ಅಂತ. ನೋ, ಇಟ್ ಇಸ್ ನಾಟ್ ಮೈ ಡಿಸಿಷನ್, ಇಟ್ ಇಸ್ ಎ ಡಿಸಿಷನ್ ಆಫ್ ದಿ ಜನರಲ್ ಬಾಡಿ, ಐ ವಿಲ್ ನಾಟ್ ಗೋ ಅಗೇನ್ಸ್ಟ್ ದಿ ಜನರಲ್ ಬಾಡಿ ಅಂತೇಳಿ ಒಂದೇ ಮಾತು ಹೇಳಿದರು. ಆವಾಗ ಯಾವುದೇ ಕಾರಣಕ್ಕೂ, ಆಮೇಲೆ ಅವರು ಹೋಗ್ಬೇಕಾದ್ರೆ RN ನರಸಿಂಹಮೂರ್ತಿ, BV ಆಚಾರ್ಯ ಎಲ್ಲ ಕರ್ಕೊಂಡೋಗಿದ್ದರು, ಮಹಾಲಯ ಅವ್ರನ್ನೆಲ್ಲ ಒಳಗಡೆ. ಯಾಕೆ ಒಳಗಡೆ ಹೋದರು ಅಂದರೆ, ಅಕಸ್ಮಾತ್ ನಾವು ರಾಜಣ್ಣ ರವಿ 3 ಜನ ಹೋಗ್ತೀವಿ, ಅವ್ರೇನೋ ದುಡ್ಡು ಕೇಳ್ಬಿಟ್ರಂತೆ, ಅದು ಕೇಳ್ಬಿಟ್ರಂತೆ, ಇದು ಕೇಳ್ಬಿಟ್ರಂತೆ, 50 ಕೋಟಿ ಕೇಳ್ಬಿಟ್ರಂತೆ, 100 ಕೋಟಿ, ಈ ಥರದ್ದೆಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಬರ್ಬೋದು ಅಂತೇಳಿ ನಾವು ಯಾರು ಸೀನಿಯರ್ನ ಕರ್ಕೊಂಡೋಗ್ಬಿಟ್ಟಿದ್ವಿ, ಒಂದು 4 ಜನನ ಕರ್ಕೊಂಡೋಗಿ ಅಲ್ಲಿ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಮುಂದೆ ಕೂರಿಸಿ ಅವ್ರ ಹತ್ರನೇ ಮಾತಾಡ್ಸಿದ್ವಿ. ಅವಾಗ ಇನ್ ದ ಇಂಟ್ರೆಸ್ಟ್ ಆಫ್ ದಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಪುಟ್ಟೇಗೌಡರನ್ನ ಶಬಾಷ್ ಅಂತ ತಬ್ಕೊಂಡು ಚೇಂಬರಲ್ಲಿ ಊಟ ಕೊಡಿಸಿ ಅವರು ಕಳಿಸಿದ್ರು. 24 ಅವರ್ಸಲ್ಲಿ ಅವನು ಸಿಕ್ಕಿಮಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದರು. ಜಸ್ಟಿಸ್ KR ಅವರು 8/8/2010ಗೆ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಬಂದು ಇಲ್ಲಿ ಚಾರ್ಜ್ ತೊಗೊಂಡ್ರು. ಇವತ್ತೇನಾದ್ರು ಪುಟ್ಟೇಗೌಡರು ಇದ್ದಾರೆ ಅಂದರೆ ಇವತ್ತು ಪಾರ್ಕಿಂಗ್ 4 ಎಕರೆ ಜಮೀನನ್ನು ಅಲ್ಲಿ ನಾವು ಡಿನೋಟಿಫೈ ಮಾಡಿಸಿ ಪಾರ್ಕಿಂಗ್ ಹಾರ್ಟಿಕಲ್ಚರಿಂದ ಇವತ್ತು ಪಾರ್ಕಿಂಗ್ 1000 ಕಾರ್ ನಿಲ್ಲೋಷ್ಟು ಜಾಗ ಮಾಡಿಕೊಡಿದ್ರೆ ಬಿಕಾಸ್ ಆಫ್ ಪುಟ್ಟೇಗೌಡ. ಇವತ್ತು ಹೈಕೋರ್ಟ್ ಕ್ಯಾಂಟೀನು ಪುಟ್ಟೇಗೌಡರದು, ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೊಸ ಬಿಲ್ಡಿಂಗ್, ಇವತ್ತೇನಾದ್ರು ನಾವು ದೊಡ್ಡ 7 ಫ್ಲೋರ್ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದ್ದೀವಿ ಬಿಕಾಸ್ ಆಫ್ ಪುಟ್ಟೇಗೌಡ. ರಾತ್ರಿ 2 ಗಂಟೆವರೆಗೂ ಅವರು ಕಾಂಕ್ರೀಟ್ ಹಾಕ್ಸ್ತಾಯಿದ್ರು ಅಂತ ಕೇಳ್ಪಟ್ಟಿದ್ದೀನಿ ನಾನು. ಅದಕ್ಕಿಂತ ಆಮೇಲೆ ಮೇಲಲ್ಲಿ ಇವತ್ತು ರೆನಿವೇಷನ್ನು, ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಹೊಸ ಬಿಲ್ಡಿಂಗು, ಮೇಲಲ್ಲಿ ಪಕ್ಕದ ಕಾರ್ಪೊರೇಷನ್ ಬಿಲ್ಡಿಂಗ್ ಎಲ್ಲವನ್ನು ತೆಗೆದುಕೊಟ್ಟಂಥ ಪುಟ್ಟೇಗೌಡ. ಅದು ಇದ್ದಿದ್ದು 1 ವರ್ಷ, 1 ವರ್ಷ ಬರೀ ಹೋರಾಟ, 1 ವರ್ಷ ಕೇವಲ 14 ತಿಂಗಳಲ್ಲಿ ಕೆಲಸ ಮಾಡಿದ್ರು. ಬಟ್ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನಿಂತಾಗ ಇಬ್ಬರು ಭಾಳಷ್ಟು ಕೆಲಸ ಮಾಡಿದ್ವಿ, ನಾವು ಗೆದ್ದು ಬಿಡ್ತೀವಿ ಅಂತ ಇಬ್ಬರು ನಿಂತ್ವಿ. ಬಟ್ ಜನಗಳಿಗೆ ನಾವಿಬ್ಬರು ಕೆಲಸ ಮಾಡೋರು ಬೇಕಾಗಿರಲ್ಲ, ಇಬ್ಬರು ಸೋತೋದ್ವಿ. ಆಮೇಲೆ ಪುಟ್ಟೇಗೌಡ ಒಂದು ಸಹ ಮನೆಗೆ ಕರೆದು ದಿನಕರನ ವಿಚಾರದಲ್ಲಿ ನೀವು ಹೇಳ್ತಾರೆ ಜಡ್ಜ್ ಮಾಡ್ತೀವಿ, ನಿಮಗೆ ದುಡ್ಡು ಕೊಡ್ತೀವಿ, ಏನು ಬೇಕಾದ್ರೂ ಮಾಡಿಕೊಡ್ತೀವಿ, ನೀವಿಬ್ಬರು ಅವ್ರನ್ನ ಕೂತ್ಕೊಳ್ಳೋಕೆ ಬಿಡಿ ಅಂತ ಹೇಳಿದರು. ಏನೋ ದೊಡ್ಡ ದೊಡ್ಡ ಆಫರ್ಗಳೆಲ್ಲ ಬಂದಿತ್ತು, ಅದೆಲ್ಲ ಹೇಳೋಕ್ಕಾಗಲ್ಲ ಇಲ್ಲಿ. ಪುಟ್ಟೇಗೌಡರು ನನ್ನ ಮನೆಗೆ ಕರೆದು, ರಾಜಣ್ಣ ಏನು ಮಾಡೋಣಪ್ಪ, ಈ ಥರ ಎಲ್ಲ ಆಫರ್ ಬಂದಿದೆ, ನಾನು ನೀನು ದೊಡ್ಡ ಸಾಹುಕಾರ ಆಗ್ಬಿಡ್ಬೋದು, ಏನು ಮಾಡಬೇಕು ಅಂತ ಕೇಳಿದ್ರು ನನ್ನ. ನಾನು ಹೇಳಿದೆ, ಸರ್ ನಾನಂತೂ ಸೋತ್ಬಿಟ್ಟು, ನನ್ನ ಸೋತಿದ್ದೆ ಹೋದ ಸರಿ ಗೆದ್ದಿದ್ದೀನಿ, ಜನ ನನ್ನ ಮೇಲೆ ವಿಶ್ವಾಸ ಇಟ್ಟಿದ್ದಾರೆ. ಅವರು ಸೋತಿದ್ರು ಪಾಪ ಒಂದು ಸಾರಿ, ಆಮೇಲೆ ಗೆದ್ದಿದ್ದೀವಿ, ನಾವಿಬ್ಬರು ಸೋತು ಗೆದ್ದವರು. ಇವಾಗ ನಾವೇನಾರ ಕೈ ಬಾಯಿ ಶುದ್ಧ ಇದ್ದಾರೆ ಅಂತ ಓಟ್ ಹಾಕಿದ್ದಾರೆ, ನಾವೇನಾರ ಸಣ್ಣ ಒಂದು ತಪ್ಪು ಮಾಡಿದ್ರೆ ಇನ್ನು ಜೀವಮಾನದಲ್ಲಿ ವಕೀಲರ ಸಂಘಕ್ಕೆ ಬರೋಕ್ಕಾಗಲ್ಲ ಸರ್. ವಕೀಲರ ಸಂಘ ಬಿಟ್ಟೋಗೋದಾದರೆ ಬೇಕಾದ್ರೆ ಏನಾದ್ರು ಮಾಡ್ಬೋದು ಅಂದೆ. ಇಲ್ಲ, ನಾವು ವಕೀಲ ಸಂಘದಲ್ಲಿ ಇರಬೇಕಾಗುತ್ತೆ ಸಾಯೋವರೆಗೂ, ಬಿಡೋದು ಬೇಡ, ನೀನೊಬ್ಬರು ಸರಿ ಇರೋ, ನಾನು ಮಿಕ್ಕಿದ್ದು ನಾನು ನೋಡ್ಕೊಳ್ತೀನಿ ಅಂತೇಳಿ ನನಗೆ ಅವತ್ತು ಒಂದೇ ಒಂದು ಸಾರಿ ತಪ್ಕೊಂಡು ಹೇಳಿದ್ರು ಅವರು, ಯು ಆರ್ ಮೈ ಬೆಸ್ಟ್ ಸೆಕ್ರೆಟರಿ ಆಫ್ ದಿ ಬಾರ್ ಅಸೋಸಿಯೇಷನ್, ನೀನು ನನ್ನ ಜೊತೆಗಿರು, ಫೈಟ್ ಮಾಡೋಣ ಅಂತೇಳಿ. ಅವರು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗೋವರೆಗೂ 24 ಗಂಟೆ ನಿದ್ದೆ ಮಾಡಿಲ್ಲ ನಾವು. ಅಂಥ ಒಂದು ಪ್ರೆಷರ್, ಅಂಥ ನಿಜವಾಗ್ಲೂ ಆ ಥರ ಪುಟ್ಟೇಗೌಡ್ರನ್ನ ನಾನು ನೋಡೋಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ಇವತ್ತು ನಾವೆಲ್ಲ ನೋಡಿಬಿಟ್ರೆ ಫೋಟೋ ನೋಡಿದ್ರೆ ಬೇಜಾರಾಗುತ್ತೆ. ಅದು ನಮ್ಮ ಎಲೆಕ್ಷನಲ್ಲಿ ತೆಗೆಸಿರೋ ಫೋಟೋ ಅದು. ಅವರು ಆ್ಯಸ್ ಎ ಪ್ರೆಸಿಡೆಂಟ್ ಆಗಿದ್ದಾಗ ಅದ್ಭುತವಾದ ಒಂದು ವ್ಯಕ್ತಿತ್ವ ಅವರು. ಬೇಕಾದೊಟ್ಟಿದೆ ಮಾತಾಡೋಕ್ಕೆ, ಟೈಮ್ ಇಲ್ಲ. ಥ್ಯಾಂಕ್ ಯು.
During the Renaissance period, the first generation of the people who laid the foundation for some of the greatest monuments like the Florence ಅಥವಾ ನಮ್ಮ ಅಜಂತ ಎಲ್ಲೋರ ದೇವಸ್ಥಾನಗಳನ್ನು ಕಟ್ಟಲಿಕ್ಕೆ ಮಾಡಿದಂಥ ಒಂದು ಪ್ರಯತ್ನಗಳು ನಡೆದಾಗ ಮೊದಲನೇ ಜನ್ರೇಷನ್ಗೆ ಗೊತ್ತಿತ್ತು ಅವರ ಜೀವಮಾನದಲ್ಲಿ ಆ ಕಟ್ಟಡವನ್ನು, ಆ ಮೇರುಕೃತಿಯನ್ನು ನಾವು ನೋಡಲ್ಲ ಅಂತ. ಹಂಗಿದ್ರೂ ಕೂಡ ಅವ್ರ ಫೌಂಡೇಶನ್ ಹಾಕಿ ತಮ್ಮ ಕೆಲಸವನ್ನು ಮಾಡಿದ್ರು. ಇಂಥ ಒಂದು ಮಹಾನ್ ಸಂಸ್ಥೆಗಳನ್ನು ಹುಟ್ಟಿ ಹಾಕಿದ ಕೀರ್ತಿ ಪುಟ್ಟೇಗೌಡರಿಗಿದೆ. ಸೊ ಅವರ ಒಂದು ನೇತೃತ್ವದಲ್ಲಿ ಇಷ್ಟು ದಿವಸ ನಡೆದು ಅವರು ದಿವಂಗತನಾದ ನಂತರ ಅವರ ನೆನಪಿನಲ್ಲಿ ನಮ್ಮ ವೃತ್ತಿ ಜೀವನಕ್ಕೆ ಒಂದು ಬೆಲೆಯನ್ನು ತರ್ತಕ್ಕಂಥ ಪ್ರಯತ್ನವನ್ನು ನಾವೆಲ್ಲರೂ ಮಾಡಬೇಕಂತ ನನ್ನ ಅನಿಸಿಕೆ. Mr. Kantharaj sir explained how the doctrine of separation of powers is now a constitutional mandate and therefore it has become a basic structure of the constitution. Similarly, our Kantharaj sir is a basic structure of the Karnataka State Bar Council. Wherever you call him, wherever, even the remotest place, he'll come and he will share his wonderful knowledge. So I personally and on behalf of the Karnataka State Bar Council, I extend an excellent and heartfelt thanks to Shri H. Kantharaj Senior Advocate. ಹಾಗೆ ನಮಗೆ ನಾವು ಧನ್ಯವಾದಗಳನ್ನು ಹೇಳ್ತಕ್ಕಂಥ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ ಎಲ್ಲ ಸದಸ್ಯರಿಗೂ ಮತ್ತು ಅಧ್ಯಕ್ಷರಿಗೂ ಉಪಾಧ್ಯಕ್ಷರಿಗೂ ಕೂಡ ನನ್ನ ಪರವಾಗಿ ಮತ್ತು ಎಲ್ಲ ವಕೀಲರ ಪರವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಅದಕ್ಕಿಂತ ಹೆಚ್ಚಿನ ವಿಷಯ ಅಂತ ಹೇಳಿದ್ರೆ ನೀವೆಲ್ಲರೂ ಕೂಡ B.V. ಶಂಕರನಾರಾಯಣ್ ಸರ್ ಇದ್ದಾರೆ, ಸ್ವಾಮಿಯವರಿದ್ದಾರೆ, ಮತ್ತು ನಮ್ಮ ಅರವಿಂದ್ ಇದ್ದಾರೆ, ಬಸವರಾಜ್ ಕುಲ್ಮಿ ಅವರಿದ್ದಾರೆ, ಪೂರ್ಣಿಮಾ ಅವರಿದ್ದಾರೆ. ಎಲ್ಲರಿಗೂ ಕೂಡ ನನ್ನ ಹೃದಯಪೂರ್ವಕವಾದಂಥ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಮತ್ತೊಮ್ಮೆ ಇಂತಹದೇ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಸೇರೋಣ. ಶುಭ ಸಂಜೆ. ಧನ್ಯವಾದಗಳು.
Mr. S. Basraj, Senior Advocate, to deliver the vote of thanks.